again, this is Andrei Minkov with the Trademark Factory. In this video, you will learn about the difference between trademarks and trade names or company names. First of all, trademarks serve a very different purpose from trade names. Trade names are used to identify a business or a company. That's why they're also often called business names or company names. Trade names are the who of the business. Customers deal with a business bearing a particular trade name. As you've learned in the previous video, trademarks are used to identify products or services, not the company. They're used to identify that which your business offers to the public. Customers buy products and services bearing the trademark. In very simplistic terms, customers buy trademarks from trade names. Again, customers buy trademarks from trade names. With the exception of numbered companies, every business registered with a registrar of companies or incorporated, provincially or federally, has a trade name. But neither the reservation of a corporate name nor the formation of a corporation create an absolute right to use the business name of the corporation in that jurisdiction. Rights in corporate names are treated like rights in unregistered trademarks, which means that unless you're actually known under that name in a specific geographical area, there's really not much you can do to stop others from adopting a similar or even identical name. Even if you register a corporate name that no one else had thought of before, it doesn't give you the right to stop others from using it, unless you can prove that the other person's use of that name creates confusion. Just because you came up with a fancy company name that helps you attract customers for whatever products or services you're offering doesn't mean that your name or brand is a trademark. If you're not using the trade name as a trademark, you don't have trademark protection for your trade name. A trade name can be registered as a trademark, but only if you use it as such. That is, to identify products or services. Let's say your company is called Awesome Software Inc. And you make, well, guess what? Software. If you phrase your marketing materials to say that Awesome Software Inc. offers such great titles as text, calculator, and presentations, you're using Awesome Software as a trade name to identify the business, not as a trademark to identify the products. However, if you phrase them to say, we offer Awesome Software Text, Awesome Software Calculator, and Awesome Software Presentations, then you're using Awesome Software as a trademark, even though it's also your trade name. The classic example is, of course, Microsoft Windows or Microsoft Excel. We don't buy Microsoft, we buy from Microsoft. But because Microsoft is part of the name of the product we buy, and really a part of the reason why we buy it, it's also protected as a trademark in its own standing. On the other hand, corporate registries don't really check if the name submitted for registration violates any prior rights. In other words, just because a provincial corporate registry approved your company name for registration does not mean that you don't violate someone else's prior right in a trade name or a trademark, and that you will not be compelled to change it in the future. You could probably register a company called Microsoft Awesome Software Development Inc. in British Columbia today. But if you started using that name in your business, it wouldn't be long before you get a letter from Microsoft's lawyers demanding that you immediately stop using that name and possibly also pay a hefty amount for infringement of their trademarks. So when should you consider registering your trade name as a trademark? There are two types of customers who may be interested in what you have to offer. The customers from the first category buy your services or products after looking for these specific services or products, as in, I've heard that Airsucker AS78 is a great vacuum cleaner. I would like to buy one of these. These customers really don't care who makes this particular vacuum cleaner because they already know what they want. Unless your company name also happens to be Airsucker, you would not gain anything with customers from the first category if you register your company name as a trademark. You would, of course, be protecting the name of the product, but as the company name goes, it's irrelevant for this first category of customers. On the other hand, the customers from the second category buy your services or products after looking for you. As in, I've heard that ABC makes great vacuum cleaners. Which model would you recommend? They are willing to rely on your expertise because they already made the decision to buy from you. If you have a significant number of customers from this category and your business is more than just you personally, you should definitely consider registering your trade name as a trademark. You will learn about other reasons for registering trademarks and about the trademark registration process in the follow-up videos. In the last video of this series, you will also learn about the unique way that the Trademark Factory can assist you in registering your trademarks. In the next video, you'll learn what cannot be protected as trademarks and about the difference between the trademarks and the products and services themselves. Sounds obvious? Don't jump to conclusions. Meanwhile, if you have any questions about trademarks, trade names, or other intellectual property issues, feel free to call me, email me, or visit our website at trademarkfactory.ca. And don't forget to read the book, The Ultimate Insider's Guide to Intellectual Property. Thank you for watching. Talk to you soon.